Niko na watoto 4. Nilikuwa naishi maisha ngumu. Nikaona maisha ya kuolewa imeniweza. Mpaka madawa kuna wakati ilifika pahali nikaweka kwa mkono nikunywe yangu iishe.
Nilikuwa naona kama ninadhulumiwa haki yangu. Hata mimi nilikuwa nimeshagive up, lakini there was something was driving me. Why mbona nidhulumiwe na ninyamaze?
Sasa hata mimi nimerefuka, katiba nimejua, sheria nimejua. Sasa sitadhulumiwa vile nimedhulumiwa wakati ule.
The National Legal Aid and Awareness program was established by Gazette Notice in the year 2008. It became operational in the year 2009, and it's a pilot project that deals with thematic areas, and among the thematic areas is children, for example, in need of care and protection, in conflict with the law and in contact with the law, that is issues of maintenance of children. It also deals with family matters, issues of succession, issues of divorce and separation and maintenance.
They dumped me because sina kazi.
Nilipokuwa naendelea na kazi, all of a sudden watu wa council wakaingia, wakaangukia vifaa zangu za kazi, wengine wakanishika, wakanitupa kwa gari yao, wakachukua vifaa zangu za kazi zote wakaweka na wakanipeleka mpaka police station. Baada ya kulipa shilingi 2,000 nikapewa receipt ya cash bond. Wakaniambia kwamba niende nyumbani. Instead wakaniambia tu niende nyumbani. Nikawaambia sasa tools zangu je, ninaenda na tools zangu ziko wapi? Kwanza niliwaandikia demand notice na advocate. Nilienda nika-engage advocate, akaniandikia demand notice. Akapewa 21 days kurelease hizo vitu. Lakini hawa hawakuleta hizo vitu kabisa. Instead ilibidi sasa, hakuna option, ilinibidi sasa ni file case in court kwa sababu nilikuwa naona kama ninadhulumiwa haki yangu.
He came to us with an issue of damaged property of his tools of trade, and we assisted him by preparing him documents to go to court. But we taught him on self-representation, how to represent himself in court. And good enough, he won the case. And he was awarded damages for the loss of his tools by the court. I can call him the firstborn child of Nalep Pro Bono Services in Kisumu.
Nilisikia mzuri kwa sababu niliona kwamba kumbe mnyonge pia hana haki. Sio vile msemo wanasema mnyonge hana haki, lakini nilikuja kujua kwamba mnyonge hana haki vile vile kwa nchi yetu hii Kenya.
Hii mafundisho upande wangu vile imenisaidia, imenitoa woka sana. Unajua nilikuwa na woka, lakini sasa nilipopata hii mafundisho niko yani na mrali, yani niko na roho sana. Naona tu kama naweza shinda kesi yangu.
Kwa sababu hata hujafungua mwanya wewe koti yenyewe utayarisha sababu utampelekea ile afisa.
We were training mostly persons who have been convicted or charged with the offense of robbery with violence. There are two offenses, capital offenses. There's murder and there's robbery with violence. Now, for those charged with murder, they had access to lawyers. But those charged with robbery with violence, they did not have that space. So, unfortunately, considering that the two offenses carry the same punishment, it seemed a bit discriminatory that one offense would get access to a lawyer and the other one doesn't.
Akataya kwamba alikuona na pale in examination alisema hakuona ama hata kwa statement yake hakuna jambo kama hilo. So those evidence, part of those evidence would be used in any kind of accuse.
Again, it goes back to the same thing I've been saying all along. If that is the evidence ameleta pale kotini na wewe hujai challenge, then the court is left with that evidence only.
The training is a week long. So we start on Monday and it ends on Friday. And in most of the prisons, by the time we get to Wednesday, you already have a few inmates coming back to give stories about how they went to court. And whereas initially they couldn't even face the magistrate or the judge, now suddenly they have this new confidence, you know, and they can stand up and represent themselves. They are aware of their rights. They can articulate their cases better. And it's been interesting. Standing orders, juu ya identification parade. Sawa.
Hata tukiwa hatuna lawyer, we are lawyers now. Tumesoma na tumejua kabisa mimi naweza jisimamia na nijikesie na nisaidie pia mwingine.
Hakika wingi wa jela vile tulivyo, si ni kwa sababu ya makosa yale tulifanya, ni kwa sababu ya na kukosa kujua.
So happy, extreme. Yeah, I'm so happy. I pray that maybe if there are some people, the stakeholders who are planning for the same, will have helped a lot, not just us, but our generation and the country as a whole. We are so grateful. On behalf of the others, I say this is kudos. And I feel if this is going to continue, then Kenyans will know the rest. The issue of violations and hesitation.
If I was the one inside charged with whatever offense, I would want to be given the facilities and the opportunity to defend myself, such that at the end of the day, if I'm actually convicted, I'm found guilty and convicted, then I know due process was served at the end of the day, that I am justly convicted, and not because I did not know that I have a particular way of defending myself. I did not have this opportunity. I didn't have a facility. So if they are guilty, they are guilty. But let them be able to defend themselves.
Who is inducing my client into an affair that he cannot be accepted.
I think we should go away and come back.
Excuse me. We are not going to.
Excuse me.
No, we are free to go.
Mr. Advocate, please come with your client.
We have been training professional mediators since the year 2010, and now we are working with NELIAB and the European Union to ensure that we get these skills to the grassroots. We want to impart the skills of a professional mediator into the elders in the community. There are so many people who cannot afford the legal process in the court system, employing a lawyer and filing their matters in court. But if we can find people at the grassroots, the source where conflicts take place, to help and assist these people to resolve their conflicts, will help a larger majority of the poor who cannot afford legal services.
Oh, I have learned a lot. I have learned that most of the cases that are piling up in courts should be solved through mediation. Mediation is very cheap and they take a very short time to complete. The other thing, they leave those people in dispute when they are friendly, as opposed to the judgment at the court.
Now pia wanaona kwamba there is light at the end of the tunnel. We must also be able to watch the body language. If for example, parties you are intending to help resolve the conflict are in the verge of fighting, unaweza kuona by reading body language. Na kazi yako kwenye sigaretu kufanya nini? Wanijon, watu waenda nyumbani, tutakutana kesho unafanya nini? Tuendelee. Kuendelea kukaa huko ni kuleta vita. The other thing you need to do.
It must have been a shock. Very big issue.
It is a very, very important and a very educative program. And I think we have gained a lot. And if this training program is put into effect among the communities in this country, we shall be able to achieve a lot of resolution to many disputes. It's a very important program.
The training that we have since been doing around the 5 counties with NALEP, and the Department of Justice and BDAG, we have seen judicial officers actually appearing in the courts, in the training sessions, and actually saying, well, it's something good. This is God sent. So whatever we are doing under Article 48 in the name of giving back to society, we are very comforted. Because even now when you appear before the judges, when you argue a case as from the Article 48 foundation, it becomes easier, it flows. The judges are a new chapter, chapter 10 of the Constitution. It's not the old judges. They are now open to pro bono work. They are receiving us. And they are also participating in activities of doing pro bono work.
What the European Union is doing and ELIAP is the best thing that this country has always been looking for since independence. I think this thing has arrived and we are here to impart it to the people and they'll go down to the ground and help them agree.
NAREP has achieved a lot. The fact that there's a bill which is coming, it's an act which is coming up because the bill is there already. The policy has been put in place. We are seeing a lot of collaboration between now the government and non-government organizations, the civil society in matters of legal aid. A lot of people have benefited. So without doubt, I think for the last 3 years or 4 years, because this was a foundation time, a lot has been achieved.
Access to justice is now a fundamental human right under the Constitution. The Constitution mandates the state to ensure that all persons access justice. The proposals in the bill are to establish a legal aid service, and this service will actually roll out the legal aid throughout the country, and being a constitutional and fundamental human right in terms of access to justice, it is expected that the service will provide legal aid and awareness to citizens, especially those who cannot afford.
We'll emphasize a lot on telling them about their rights and what it is that the service can do for them. The service is not expected to handle all types of cases. We'll set out a criteria that we educate the public on the type of people that the scheme, the service, the legal aid scheme is targeting. And mostly they have been defined in the bill itself. And once it becomes law, these are the vulnerable and the very poor people. And in this case, the categories have been laid out as children, women, the IDPs, the refugees have also been identified as very vulnerable people. And apart from the people, again, the criteria that we educate people on is the type of cases, again, that this service can help people in. And mostly for criminal cases, people already convicted and people on death row, these have been in the pilot before and they will still continue because they are vulnerable. And for the civil cases, the cases that usually are targeted will be matrimonial issues, issues to do with children, property issues. In most cases, we will not handle cases of debt, related issues, where you owe another person some money. But if any of the issues that you have touched on any violations on the rights as enshrined in the Constitution, then the scheme will be able to assist if the criteria that's set is met.
That access to justice has been, for many Kenyans, for too long an abstract concept. Many Kenyans did not have access to justice. So for the EU in supporting access to justice efforts over the years, we aim at reaching at one point in this country basis for a structure and sustainable legal aid scheme for enabling many Kenyans to access effectively to justice. And in doing so, we follow general principle of the EU that enabling justice in a given society is part of building institutions But equally important is also about building cohesion, unity, that are for us the foundation for a growing economic prosperity that should be the ultimate goal of development efforts. So this is our motivation in supporting access to justice efforts.